Welcome back to LexTalks, Legal Topics Simplified, where we break down Indian law and make it easy to understand. Today, we're going to be taking a deep dive into something you'll come across a lot in your legal studies, the relationship between a banker and a customer.
It really is foundational. You'll see it pop up in so many different areas of law, from contracts and financial transactions to property law, even consumer protection.
Exactly. We've got a ton of research here, legal journals, recent case law, all to really unpack this concept.
It's going to be a fun deep dive.
I think so too. Now I know what you're thinking. I already know what a bank customer is. I am one.
Right. We all use banks in some way.
But there's a whole legal side to this relationship that's much more than just having a debit card or a savings account.
It's true. Legally speaking, this relationship has a very specific definition. It's
Yeah.
way more nuanced than you might think at first.
Okay, so let's get right to it. Legally, what actually makes someone a customer of a bank? Is it really as simple as opening an account?
Actually, it's a little more complicated than that. Just opening an account doesn't automatically make you a customer in the legal sense. The real key is whether there's a whole series of transactions between the bank and the person. It's more about that ongoing back and forth, a series of steps in a financial dance, if you will.
A financial dance.
Yeah, like a partnership.
I like that. So it's not just a one-time thing or just having the account. It's about that engagement, those transactions.
Exactly. Every time you do something with the bank, deposit a check, take out a loan, even just using the ATM to get cash, all of those individual actions, they add up to build that banker-customer relationship, legally speaking.
So each transaction is like another layer to the relationship.
You could say that, yeah.
Yeah.
And as the relationship grows, it falls under a whole framework of legal principles, mainly coming from the Indian Contract Act and the Negotiable Instruments Act.
Okay, so we've got those transactions as the foundation. But what else makes this relationship stand out legally? What are some of its unique characteristics?
Well, one of the most important things is that it's based on contract law. Anytime you open an account or do any kind of business with a bank, you're entering into a legally binding agreement.
So even if we don't always realize it, every interaction we have with a bank has those contractual obligations behind it.
Absolutely. And these contracts can be explicit, meaning they're actually spelled out in writing. You often see this in the paperwork you sign when you open an account or if you get a loan.
Right, and they can also be implied, meaning they come about from how both sides act and what's considered normal in the industry.
Okay, now you're really making me think. Can you give me an example? How are those explicit and implied contracts different in the real world of banking?
Sure, let's say you always deposit your paycheck into your bank account every month. Even if there's nothing specifically written in your account agreement saying the bank has to take those deposits, the bank's been accepting them over and over again, so that creates like an implied contractual obligation.
So it's like an unspoken agreement, just based on how things have always been done. Exactly. And those implied contracts, they are just as legally binding as something written down and signed.
Yeah.
It's really interesting how the law picks up on the subtle things in the banker-customer relationship.
It is. Okay, so we've got these contract ideas as the base. What happens if things go wrong? Like, what if the bank and the customer have a disagreement? Do they just end up fighting it out in court?
Well, hopefully it wouldn't come to that. But yeah, sometimes there are disputes. That's where those court cases we talked about come in. Those judgments, they give us real-life examples of how these contract principles actually get used in specific situations.
So it's like case law is a guidebook for figuring out this whole relationship.
You could think of it that way, yeah. A good example is that big case, Modigavri versus Naranjan Warkadas. The Bombay High Court really clarified how the debtor-creditor relationship works in banking, and that case set a precedent that still affects how courts look at these relationships even today.
That's a great example. It shows just how important those real court cases are for understanding how these concepts actually play out. Now, you mentioned before that there's more to this relationship than just having an account and doing transactions. What are some other roles that a bank might have in this whole thing?
One of the most common relationships is the debtor and creditor one. When you put money in your account, you're basically lending that money to the bank. They become the debtor, and they're obligated to pay you back whenever you ask for it.
And then if the bank gives me a loan, I become the debtor and I have to pay them back with interest, right?
Exactly. It's constantly shifting back and forth, depending on who owes what, kind of like a financial seesaw. But it goes beyond just those deposits and loans, too.
Really? Tell me more. What other roles can a bank take on?
Well, think about it this way. What if you need a safe place to keep important papers or valuable things? In that case, the bank can act like a trustee holding onto your stuff for safekeeping.
So they're not just keeping my money safe, but also maybe family heirlooms or important legal documents.
Right. They have what's called a fiduciary duty, a legal obligation to protect your stuff and act in your best interest. It's all about trust.
That makes sense. Wait, but there's even more, isn't there? What about when I need the bank to help me out with things like depositing a check or paying my bills?
You got it. In those cases, the bank becomes your agent. They're acting for you and following your instructions. It's like they're an extension of you in the financial world, taking care of things on your behalf.
So they can really wear a lot of hats in this relationship. Does that change things legally? I mean, do those different roles affect the rights and obligations for both the bank and the customer?
Oh, absolutely. Each role has its own specific set of legal stuff that goes along with it. For example, we have the recovery of debts due to Banks and Financial Institutions Act of 1993 that was made specifically to make it easier for banks to recover debts.
So if someone doesn't pay back a loan, this act gives the bank a clear way to get their money back legally.
Exactly. It's super important for keeping the banking system stable. But it's not all about protecting the banks either. You have things like the Lender Liability Act, which sets rules for fair practices so borrowers aren't taken advantage of with unfair terms.
That's good to hear. Sounds like Indian law is trying to make things fair for both sides in this relationship.
You could say that. And it's also important to remember this relationship isn't set in stone. It changes as new technology comes along and as the financial world changes. Like with online banking and mobile payments, all that new stuff brings up new legal challenges and things to think about.
Makes a lot of sense. So you're saying understanding this relationship isn't just about knowing the laws, but also keeping up with all the new things happening in banking. But with all these different sides and legal frameworks, it can feel kind of overwhelming. What are some key things that our listeners who are studying law should really focus on?
I think the most important thing to remember is that it's all about balance. It's about understanding what rights and obligations both the banker and the customer have, and how those things work together to create a system where financial transactions are fair and responsible.
It's like a dance where each person has their own steps, but they have to be ready to adapt and respond to what their partner's doing.
Yeah, that's a great way to put it. As you learn more in your legal studies, you'll see how this mix of rights obligations and changing circumstances really plays out in all sorts of situations in real life.
Wow, this deep dive has really opened my eyes. I'm starting to see all the legal stuff that's happening behind the scenes with every bank transaction. But before we finish up, is there anything else that future lawyers should know about this whole banker-customer relationship?
Yeah, there's one more super important thing we should talk about. The bank has to keep its customers' information confidential.
Oh, right. They can't just tell everyone how much money I have in my account, right?
No. Exactly. Banks have a strict duty to protect their customers' information, and they can only share it under very specific conditions, like if a court orders them to or if the customer gives them permission.
That makes me feel better knowing that my financial info is protected.
It all comes back to that trust that we talked about, which is so important in this relationship. And speaking of trust, there's another duty we should mention, the bank's obligation to honor its customers' checks.
Yeah, that makes sense. I wouldn't be very happy if I wrote a check and the bank just decided not to pay it.
Well, remember, this relationship is built on a contract, and part of that contract means the bank has to honor those checks as long as certain conditions are met.
Like having enough money in the account, obviously. What else has to be true for the bank to have to pay the check?
Well, yeah, having the money is a big one. But there are others too. The check has to be written out and signed correctly. It can't be post-dated or too old, and it can't have any changes that weren't allowed.
So there's a whole list of things the bank has to check before they can cash a check. It's not just about having the money available.
Right. And if a bank wrongfully dishonors a check, which means they don't pay it when they should have, they can actually be held responsible for any problems that causes the customer.
So the bank can get in serious legal trouble if they don't handle checks the right way. It shows how important their responsibilities are in this relationship.
Absolutely. It goes back to keeping that balance between rights and obligations that we've been talking about. It's what makes this whole banker-customer relationship work.
This has been such an amazing deep dive. I feel like I understand this whole legal side of banking so much better now.
It's pretty cool to see how much law is involved, even in something as normal as going to the bank. And for all you future lawyers out there, remember, this is just the beginning of learning about this area of law. Keep exploring, asking questions, and digging deeper.
Exactly. There's so much to learn about law. Thanks for joining us on LexTalks. Don't forget to subscribe for more easy-to-understand legal insights. See you next time.